As I mentioned, 6 of the 8 justices either filed or joined a concurrence. Now, while all 6 of those justices agreed with the opinion, noting relatively minor differences in their concurrences, Justice Barrett did make one statement I think worth commenting on. Despite its unqualified text, the Second Amendment is not absolute. It codified a pre-existing right, and the pre-existing limits on that right are part and parcel of it. Even though Justice Barrett notes that the text of the Second Amendment is unqualified, she wants to put qualifications on it. Here's the problem I have with that. Justice Barrett is simply ignoring the text of the Constitution she doesn't like. Yes, the Second Amendment is unqualified, just as the First, Fourth, Sixth, Seventh, Eighth, Ninth, and 10th are. But that doesn't mean there are not situations where an individual cannot exercise their rights. As Benjamin Franklin, writing as Silas Dogood, said, without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man as far by it he does not hurt or control the right of another. And this is the only check it ought to suffer, and only bounds it ought to know. The limitations of the exercise of our rights does not extend to harming or controlling others. For example, in the case Schnecht versus United States, the Supreme Court recognized that a person could not use the First Amendment to defend false claims meant to hurt others, also known as the fire in a crowded theater situation. And just as a person cannot use their freedom of speech to harm others, neither can someone use their right to keep and bear arms for such a purpose. And according to Benjamin Franklin, that is the only check it ought to suffer.